Hi everyone, Jeff Marion here. Welcome back to my YouTube channel. A big verdict came down in the 3M Combat earplug trials, and I'll tell you all about it in this video. This is a series of videos designed to help you understand personal injury law. I do videos on the 3M Combat earplug litigation, like this video. I also do videos on other topics in personal injury law, like this one. So, check out my channel, click on the subscribe button, and also click on the bell to make sure that you get notifications when new videos come out. I've been fighting for people that have been injured in crashes, by unsafe products, and in falls for over 25 years. I created this channel to help keep you informed and help keep you safe. On December 10th, 2021, a jury in the Northern District of Florida Federal Court awarded Theodore Finley, a U.S. Army soldier, $7.5 million in compensatory damages and $15 million in punitive damages. This is the latest verdict in the 3M Combat earplugs litigation. In this case, Mr. Finley was in the Army from 2006 to approximately 2014. He used the earplugs and suffered severe hearing loss. 3M has known that these earplugs were defective and wouldn't do what they told the government that they would do. And as a result, they have been found liable by a jury. This is obviously the largest verdict in the bellwether trials so far. We've had 8 trials to date. 5 have gone in favor of the plaintiffs for a total of about $29 million in damages. 3 have gone in favor of 3M. Do you have any questions about this litigation? Please leave them in the comments section below. I check the comments regularly, and I'm always happy to answer your questions. So again, where are we at with this litigation? Well, the first thing you need to be aware of is that there are still 2 more trials that are underway as we speak, and I'll be keeping you posted on those verdicts as they come in. But also, what is it that 3M can do at this stage? Now, they have a couple of options. What they can do is they can ask the judge to set aside the jury's verdict. They can ask for a reduction in the punitive damages. They can ask for a reduction in compensatory damages. Generally speaking, federal judges do tend to be a bit more conservative, and they may not use the same standard that the jury did. When you're talking about $15 million, what the jury may have looked at is an amount of sales that they made, whether that's over a period of 1 day, a week, 2 weeks, a month. A good example of that is in the old McDonald's coffee case, where a woman spilled 180-degree scalding hot coffee on her thighs and on her groin, suffered 2nd and 3rd degree burns, and went to a trial. The jury in that case awarded about $200,000 in compensatory damages, but $6 million in punitive. Where did they get $6 million from? What they did is they took 1 day's coffee sales worldwide for McDonald's. So this could be something that the jury hung their hat on in terms of an amount of sales, an amount of profit that they made from these combat earplugs, and asked basically 3M to return that profit. The other thing that 3M can do is they can appeal the case to a higher court, to the Court of Appeals, and they can also make the same arguments that the verdict is against the weight of the evidence, that it's excessive, etc. But one thing I think you should keep an eye on is whether 3M is going to be eyeing bankruptcy court in this case. If you've been following the opioid cases, you know that Purdue Pharmaceutical filed for bankruptcy in the Southern District of New York. As a part of that, that is where all of the municipal claims and also individual personal injury claims were handled in that particular bankruptcy. It's still awaiting final approval, but the point is that 3M may be looking at what are now 270,000 plus cases and saying they A, can't afford to fly all over the country and try these cases, B, can't afford to get hit with big verdicts 60-70% of the time, and may look at what their liability would be and file in bankruptcy court. What does that mean for the litigation potentially? What will happen is that as a part of it, 3M will essentially put a whole bunch of money on the table, and the litigants will divide it up amongst themselves based on what types of injuries you have. So 3M is not out of options, but I would keep a very close eye on bankruptcy court as a potential landing place for this litigation. If you were in the service between 2003 and 2016 and you suffered hearing damage as a result of use of 3M combat earplugs, please contact me at the email address below, or you can reach me through my website at www.jeffmarionlaw.com. I'll sit down with you for free and go over your case with you and see if I can help. I want to thank all of you who've made this particular portion of the channel a success. I really enjoy seeing the feedback. I enjoy the comments. I really love interacting with you guys. You have great questions for me, so keep them coming. But make sure that you also subscribe to the channel, check back here regularly, click on the bell, and until the next verdict comes out, we'll see you in the next video.